speak about the side events and all other programs. So, and I see that some others are, some other people for this session are still to join us, including one of the panelists who is not with us yet, but will join us later. You can see the participants. I'm Ivan Szekely, the moderator of this panel discussion from the Central European University. Professor Charles Raab, at the end of the table, who is indicated as co-organizer or co-convener of this panel discussion. In earlier years, he was called chair, but the function of the chair has been abolished in the internal regulation of the CPDP. But nevertheless, he will have a special role in this discussion. And we have a panel of excellent experts, including the one who is just joining us, Fanny Coudert, who is the first in alphabetical order. Just take off your coat, Fanny, and there's a chair in the middle for you. So Fanny is from the European Data Protection Supervisor, the EDPS. Then in alphabetical order, it's Marit Hansen, who is Privacy Commissioner in Schleswig-Holstein, Germany. Then Mark Leiser. This is the only way you can get in and get out afterwards. Mark is from the Leiden University, and Maté, Szabó, sitting in the middle. He's from the Hungarian Civil Liberties Union. You will have a chance to read their short CVs on screen later during the discussion. But, and this is the right computer, so. This is just to demonstrate that this is not the first time we are organizing a panel discussion about DPAs and some aspects of their activities. We are proud, together with Charles, we are proud to have had such a panel of distinguished speakers in earlier years on panel discussions about DPAs and their independence, DPS and NGOs, DPS and information technologies, and so on. So, but we are equally proud of having these distinguished speakers on the panel. And let me say a few words about the structure of the discussion. First, in the first round, each speaker will have an opportunity to present a short kind of introductory notes or a presentation as an introduction to the panel discussion in 6 to 8 minutes. And I'm entrusted with the uneasy task of reminding our panelists to keep the time. But I can show everybody that I'm using a stopwatch, and we also have a very strict schedule, and I try to keep the time. If it doesn't work, I have less educated means to use. This is 2 minutes, please, and this is please stop. But I do hope that I won't need to use these tools. So about the structure. So after this round, there will be another round of internal discussion, so the panelists can reflect on each other's presentations or refute statements and debate and so on. I hope this will be a lively discussion. And at the end, I will give the floor to the audience for questions and comments. This is not unusual. What might be unusual is that I will interrupt sometimes your convenient role of a silent listener and would like to ask your opinion in the form of quick votes, like a kind of blitz voting session. But that's towards the end, but we'll see how it goes. So first of all, I would like to turn to Charles and ask him to deliver a kind of introduction to the whole panel and to the whole subject we are going to discuss today. So Charles, please.
Thank you very much. Is this on? Yeah. Thank you very much. As Ivan has said, the CPDP police have abolished the role of chair, but as long as I have a chair to sit in, I will sit in it while I give my remarks. Welcome. It's very nice to see you here so early in the morning. The relationship between data protection authorities and law enforcement agencies has always been a very sensitive issue. Reconciling law and order interests and security on one hand and fundamental rights on the other, as well as finding the least privacy-intrusive means to fight crime and terrorism. That sets the stage for the work of DPAs in this area as well. And the increasing use of artificial intelligence, AI, in policing and in law enforcement has generated very many critical comments from civil society organizations, and also poses new challenges for DPAs themselves, I think, not least in terms of public expectations of how the application of AI and other advanced technologies can be kept within the bounds of some famous concepts: fairness, lawfulness, and human rights. Well, this panel aims to consider and debate these issues amongst ourselves and with you in the audience. And I think a very important place to start is by referring to data protection's dirty little secret, which nobody really has done very much research about, which is the EU Police Directive 2016-680. Which I'm sure, as you know, accompanied the GDPR and is supposed to be transposed into national law in the member states, although I think up to date only about half of the member states have actually transposed it, and there's some anxiety about that. The directive has two aims: better protection of the individual's personal data processed by law enforcement authorities in the member states, both in purely domestic processing as well as in cross-border exchanges of data, and on the other hand, a more efficient and effective exchange of data due to harmonization. In 2018, the directive, as you know, replaced the framework decision on the protection of personal data processed in the framework of police and judicial cooperation in criminal matters. And 6 months ago, as I mentioned, because only some countries have transposed it, the European Commission lodged complaints against Greece and Spain, and also against Germany regarding the non-transposition by some of the land governments in Germany. And in the UK, where I come from, the transposition took the form of a very large section of our new Data Protection Act 2018. It's Part 3 of the UK Data Protection Act. Now, I think Mark Leiser is going to talk about this a little bit more, but it's important to note that the directive, the police directive, only applies where the data controller is, quote, a competent authority carrying out, quote, law enforcement purposes. And these are defined in the UK Act as the prevention, investigation, detection, or prosecution of criminal offenses or the execution of criminal penalties, including the safeguarding against the prevention of threats to public security. That's the end of the quote. In other words, it doesn't only apply to organizations that are specifically police forces. It could be any public or private body with regard to its law enforcement activities. For example, you take a local government authority prosecuting fines against members of the public for littering, or where a private company has been entrusted with public authority powers to be performing data processing for law enforcement purposes under contract. That could come under the law enforcement directive as I understand it. And it does not apply to the other data processing activities that a specifically law enforcement organization, like a police force, might be doing. For example, police forces processing its own personnel records, as I understand it, would come under the GDPR rather than under the law enforcement directive. So it's quite complicated. So therefore, it shouldn't be called a police directive as such, because it has potentially wider applicability, although although the relationship is very complex. But whatever the case may be, it poses some challenges, I think, for data protection authorities. They are the supervisory authorities under both GDPR and the directive. Well, so much for all the legal definitions and the formalities. We're going to learn more about these things from the panel, but what we are also here to discuss are some of the broader issues of how DPAs are or might be involved with regard to data with reference to law enforcement activities carried out by a wide range of data controllers, and of course also within individuals and groups who are subject to law enforcement or who have rights under the directive and its national implementation. And in the EU, which unfortunately my country is about to leave, these involvements bring to the fore the national and international institutional position of DPAs and other authorities who play a role in supervising law enforcement activities where personal data is collected, used, or shared. So what powers do the DPAs have to do this supervisory work? How do they know and how can they investigate where the law enforcement agencies, what the law enforcement agencies are doing with their data, and whether the agencies are acting responsibly as well as lawfully? And what happens internationally on the question of coordination between supervisory authorities and in the role of Europol? These are the issues of transparency and accountability, and they're related to the overall theme of CPDP 2020, which has to do with data protection and artificial intelligence. And in keeping with this theme, we should note that some of this DPA involvement could be with reference to the lawfulness of using AI and other technologies, such as the use of biometrics to identify individuals or facial recognition. We heard a lot about that yesterday, and so on. These techniques and systems are becoming increasingly important and controversial in the law enforcement world, at least in my country, and I'm sure in other ones. So how do DPAs keep abreast of these technical developments, technological developments, in order to carry out their own supervisory functions? So we have a very distinguished panel to address these issues, and let me turn the floor back to Ivan now to proceed. Thank you very much.
Thank you, Charles. And now I would like to turn to you. We would like to learn your opinion in certain questions. Let me warn you in advance. These questions will be oversimplified, very short, and not refined. But still, it's important to learn your opinion. So, where is the page down? No, this one. It works like this. So, there's a voting question. In your opinion, do national security and counter-terrorism objectives limit the exercise of DPA's supervisory role in practice? That's the question. We have three options. One, yes, it is always difficult for DPAs to supervise the law enforcement sector. Option two, no, DPA's supervisory activities are always respected by the law enforcement sector. But there is an option three, two, only in exceptional cases may DPAs face difficulties in supervising the law enforcement sector. So who would vote for option one? Please raise your hand. I would say this is the majority, but let's see. Who votes for option two? DPAs are always respected in the sector. Nobody. Okay, and option three, only in exceptional cases, a few persons. You seem to be very critical audience, and that's very good. But later on, we will get back to this question or to other questions. That's also a tradition of the panels we are organizing together with Charles. But now, I turn to Mark and ask him to deliver his introductory presentation. Please, Mark.
Thank you. I'm going to start with a little introduction about myself, because I think it's important to put my work into context. I wouldn't describe myself as a data protection academic. I would describe myself as a regulatory theorist. So I look at the law enforcement directive, I think, a little bit differently than some of my colleagues and maybe some of you. That being said, when I started looking at the LED, I found it quite puzzling. Puzzling in its structure, puzzling in its layout, and like Charles has indicated, the dirty little secret is that academic and the the response to it has been quite lacking, and there's been very little engagement with it. Which, considering the amount of effort and time that we spent looking at the GDPR, private actors, and of course state surveillance, to be quite disturbing. It did seem to be passed in line with the GDPR. It was part of a package approach. It has broad scope of application. Like Charles said, it has a specific process and scope and objective. It does have several things written on the tin, as we like to say. I don't think it comes close to living up to what it says on the tin. The first one is data subject rights. I don't think it comes close to it doesn't come close to sort of being able to deliver what it says about high levels of protection, but maybe we can come back to that a little bit later. It borrows heavily from the GDPR. I don't think it's any great stretch of imagination to look very far. It relies on several of the data protection principles, processing lawfully and fairly, collected for specific purposes, accurate and updated when necessary. But in a law enforcement context, how does a data subject actually do that? How do they ensure that the data that is collected by a law enforcement agency is accurate or processed fairly and lawfully? It also requires certain elements of transparency, but due to the context of law enforcement, it can never be as transparent as you would hope or would imagine under the GDPR. And that's obvious for the prejudicial effect it would have on investigations. But strikingly, I think where I want to spend a bit of time talking about is some of the legal requirements of the law enforcement directive. The first one is time limits. The directive requires that law enforcement authorities establish time limits for erasing personal data or for a regular review of the need to store such data. It also creates a categorization requirement, and this categorization requirement is twofold. The first is that any data that's processed on the behalf of a data subject must be linked to a category. This could be an accused, a suspect, a victim, a witness, and somebody that's been convicted of a crime. And just as a little personal note, I was speaking to my sister actually about this, who is a CSI for the American federal government. And we both kind of just shook our head, like how does this work in the real world? How do you look at a situation and determine whether somebody is a witness, a suspect, a convict, and then tie data deletion requirements to the elements or to the categorization of the data subject within the remit of the law enforcement directive. The other thing that it does is it requires law enforcement to characterize fact versus opinion. And I really struggled with this notion of this idea about what exactly a fact versus an opinion is and the benefit of it. I have traced this back to, maybe somebody else can highlight this, but this practice under Article 29 of the Europol regulation, in which law enforcement agencies were able to share information about crime across borders. So for example, we have an informant. He's given us this information about a crime that might be happening in your territory. We value his information as very high level. We're going to give it a category 5. Or somebody else, this person's made a statement. We don't see him, but we're going to put it into the workspace, and we'll give it a category 1. So it's a qualitative analysis of information to give a second party some additional information about the quality of the information that's being shared amongst law enforcement officials. And that's conceptually in line with the European Court of Human Rights jurisprudence, but I don't think that process actually works in the ground when you're talking about law enforcement officers on the front line having to make a determination about whether or not somebody is a good suspect or a bad suspect or a good witness or a bad witness. And if you look at it in a criminology sense, Mandelson, for example, has said that there are 6 types of victims. And one of them is that somebody that's guilty but actually perceives themselves as being a victim. The notion of facts and opinions and characterization of data subjects within a criminal event, what I'm seeing is that it's not being it's not followed very well or very accurately when the law enforcement directive has been implemented by the law enforcement agencies in different countries. What I do see is that, to be fair to the police and law enforcement, they are taking things like data protection impact assessments very seriously. I have seen very, very good data protection impact assessments, but it begs the question, then what? What happens after that impact assessment is completed? It's not clear because data subjects don't know their rights and don't know who to exercise them against. Secondly, when you start thinking about the implementation of the rules around categorization of facts and opinions and data subjects, what does that mean then for the people who are incorrectly categorized? What sort of data subject rights can they exercise against a law enforcement official? And much like data protection, I have to say, a lot of it seems great on the surface. You write a law, it looks very clear, it sounds like it makes sense, but then on the ground, people are really struggling with implementing it. And I'm like Charles Scottish, but I live in the Netherlands, and what I hear from people in the Dutch police is that they have relatively ignored this aspect of the directive because their implementation act has permitted them to do so, and that it doesn't work in practice, it doesn't have any real meat, and that because everybody's struggling with it, they do their best, but there's zero interaction with the regulator over them abiding by the regulation. And so I know I'm going to kind of wrap this part of the introduction part up. I don't think forced logging and categorization works. I particularly am interested in how this is going to work with non-law enforcement agencies who do satisfy the threshold of a competent authority, who are processing data. There's lots of things to consider, particularly with private parties who are processing personal data that happen to then be part of a law enforcement investigation, and how that integration will start to take place. But so far, I would say my impression of the data protection regulator in this space has not filled me with confidence, and I do think that that goes to the heart of some of the conceptual difficulties with the law enforcement directive itself and its practical application when put into effect. And I'll close there. Thank you.
Thank you very much. It was very interesting at the practical level, your opinion about the usefulness or uselessness of the data protection impact assessment, which is a very formalized, very easily tick box type assessment. And maybe that's the reason why law enforcement authorities and other people like that. But it raises more problems than solves. Let me turn to Fanny with a warming up question. Recently, I read an earlier paper of you, which you wrote about 5 years ago, together with 2 other authors, about the body-worn cameras by the police, body cams in short. My informal question to you is, in your present position within the EDPS, do you still have time, energy, interest, mandate to deal with such practical problems like body cams in the police? Or not?
No.
It was a short
Easy
answer,
question.
very clear. Okay, yeah. But the floor is yours, so please take the floor.
Okay, good morning. Thank you for the introduction. So this panel is about the law enforcement directive, so let me start by saying that the EDPS has no competence to supervise the implementation of the law enforcement directive, but Regulation 1725 which is a regulation applying to data processing activities by EU agencies, contains specific chapters on the processing of, by these agencies, of operational data, which basically mirrors the law enforcement directive. So it applies, for instance, to the processing by Frontex of operational data, since they got this new possibility with the new Frontex regulations since the 4th of December. But I would say that for the moment, most of our supervisory activity relates to Europol, for which we become competent to supervise since the 1st May of 2017. Eurojust, that we are competent to supervise from the 12th of December of 2019, and when the EPO regulation comes into force, we'll also be competent. So let me share maybe some points, some of our experience with this supervision, which is rather new. So I will confirm that one of the challenges is the complexity of the systems of this environment, the opacity of these activities, and the amount of data processed for different purposes. For instance, Europol has almost 30 different analysis projects, so it means more or less 30 different crime areas. So this requires to build specific expertise, specific knowledge about how law enforcement act, to understand and be able to make the balance between implementing data protection in this specific environment. I would say there was two main challenges in this area. One refers to the fact that member states send larger data sets to Europol as they collect in their day-to-day, in their investigative practice, larger amount of data. So this raise the question how to implement data protection principles such as data minimization, but also which tools to use. And here I would like to link it maybe to the question on algorithmic policing. Europol has no coercive powers, so we are not faced with predictive policing yet, at least. But, and I think most of law enforcement authorities are faced with that right now, is how to process this large amount of data sets that they have, how to extract meaningful information from it. And it comes to which tools they are using to process this information. And the point I would like to make in this regard is, there is a question of, do they have to buy these tools to the private sector, to external service provider who develop them themselves? And I think that's a very, very important question. Knowing all the problems in the field of algorithm and AI about the black box explainability, etc. So if we if we are of the opinion of allowing law enforcement authority to develop their own algorithm, to develop their own tool, this means that we will be also confronted to which safeguards to implement in order to authorize the use of operational data for research purposes, so for developing statistical and machine learning model which can be used to perform tasks such as inference, classification, automated data processing. And here there is this the first problem, I would say, the legal basis. If there are no explicit legal basis, which normally it's not explicitly foreseen, for the secondary use of this operational data for purpose of scientific research. So the EDPS recently published a preliminary opinion on data protection and scientific research, where it proposes some criteria of interpretation for this derogation. This is not an easy topic. We all understand the stakes. And one of the question is, would this activity qualify as scientific research, or better say maybe under which conditions this activity would qualify as scientific research? And here we have the question of which standards, methodologies, and ethics are applied to these activities. Also whether the research is being disseminated or carrying out in the name of growing society's collective knowledge. So this raises a complex question applied to law enforcement sector. Another challenge I would like to raise, at least in the field, is maybe linked to your first question of interplay with national security, counterterrorism, and law enforcement. At EU level, it's a different, for me, it's a different field or realm that are next together, and the exchange and the data flows between these different domain area with different regulation, supervisory activity. And at EU level, what we are faced is increased data flows and data exchanges between the GHA agencies. They get new legal basis to exchange data between themselves. And also because of the interoperability project, where GHA agency also gets more access to law enforcement, member states' data contained in EU large-scale system. And this is actually leading us to reconsider the way how we supervise these agencies in order to remain efficient in the way how we ensure respect for fundamental rights. This means that we cannot look at one agency in isolation, but we need to look at data flows. And that's the part that we'll start exploring. This also means that an important element in the supervision is to strengthen, to have closer link with national supervisory authorities. We cannot act alone. The problem normally has a broader dimension. And we already see the added value of such cooperation in, for instance, the context of the Europol Cooperation Board, which gathers supervisory authority of national law enforcement authorities. But we also see the challenges linked to such close collaboration. For instance, because of limited resources of data protection authorities, you all have different priorities, different agendas. So it's positive, but as one of the challenges we are faced with. And so maybe to finish with the last question that was addressed to the panelists with what is it better to extend DPS responsibility for regulating the law enforcement sector to let it to other supervisory authorities? I would really like to stress the added value having data protection authorities supervising law enforcement, at least in what relates to personal data processing and the impact of these processing activities on fundamental rights. Because we act, we see from our experience that we act actually as counterweight by bringing a different perspective, which is a human right approach, which is a different approach than police. I mean, police is moved by other need to protect other public interest. So we approach this with a different mindset. So, and it's also the other advantage that we are expert in data protection. So we can really act as support also to police to implement new and actually complex concepts such as data protection impact assessment or privacy data protection by design, or what does it mean, which safeguard for the processing of publicly available data, to give some examples. And maybe a third advantage I see is that we can act as proxy as well for the exercise of data subject rights and as enabler of these other counter rights to the activity of law enforcement authority in a democratic society. And just to I'm not saying that the data protection authorities should be the only supervisor of police. On the contrary, I think that as far as roles are clearly defined, having several supervisory authorities is beneficial because it can lead to a positive reinforcement with each supervisory authority bringing a different perspective, so focusing on a specific aspect of law enforcement activities. And that's something we can see with Europol, with the political supervision by the Joint Parliamentary Scrutiny Group, where it means that Europol scrutinizes different ways for the same topics. Thank you.
Okay, thank you. Let's ask the opinion of the audience about these questions. So if I find the controller, a voting question. In your opinion, which option is better? To extend the DPA's responsibility for regulating the law enforcement sector, that's option 1. Option 2, it's better to share it with other supervisory authorities, as you just suggested. Or option 3, completely leave it to other supervisory activities. So who would vote for option 1? Please raise your hands. Let's say 5. Who would vote for option 2? Quite a big majority. And who would like to leave it to the other supervisory activities, agencies? Yes, a few. So the majority voted for the sharing of the responsibilities. And now I turn to Maté, who I'm absolutely convinced that who has a very strong opinion on this, on the basis of experience.
Thank you, thank you, Ivan. The majority of my fellow panelists here, and I think a big proportion of the audience is working as or working for a data protection authority. So I feel a big trust in data protection authorities here, even though I saw the results of this voting. I have to admit that I was also working for a data protection authority after my graduation for a couple of years, and it was enough for me to fall in love with privacy protection, but it was also enough for me to make me critical with the institution, especially with my own institution, the Hungarian Data Protection Commissioner and the latter institution, but with the institution in general as well. Today I would like to talk about a little bit would like to address this question with a little bit limited scope. I would like to address the question that is the data protection authority is the best choice for being the main control instrument over the covered data collection of law enforcement and national security services. So now I'm not talking about the regulating competencies, but the control mechanisms on the individual level, so on the individual cases. My short answer for this question is no. Before elaborating this answer, I would like to, and give reasons for that, I would like to point out why I think it is a relevant question. In 2016, the European Court of Human Rights ruled that the secret information gathering made by the Hungarian Counter-Terrorism Center, which is the part of the Hungarian police, should be controlled by an independent body through an effective control mechanism. This case was the Szabó and Vichy versus Hungary case. This case is in the execution phase now. Since 2016, the Hungarian government tries to find out what kind of control mechanism would comply with the ruling of the ECTHR. They looked around and found the Data Protection Authority, the national one, as a perfect supervisor to be designated. A new bill has been drafted about this designation, but the bill has never been discussed, and it was withdrawn by the government. Until now, there is no solution for this problem, but the last idea of the government, which was made public, is to vest the DPA with new powers and competencies relating to the control mechanisms. I think it would be a bad idea. Why do I think this? From the viewpoint, from the aspect of the constitutionality of secret information gathering, it is particularly important which organ is responsible for exerting external control over surveillance performed by the state. I was one of the petitioners of this case. I mentioned the Szabó and Vichy case. I'm the Szabó in the name. Our intention when we launched this case was that we wanted to point out that the control mechanism should be mainly judicial. While the judgment of the ECTHR recommends judicial control, the draft bill assigns the task to the DPA without pointing out why choose the authority instead of the courts. The court in the judgment makes a distinction between the control mechanism over the authorization and the a posteriori control. But unfortunately, the court doesn't make clear that the latter doesn't substitute the first one. The judgment is indistinct regarding this issue. It can have two different interpretations. The first is the authorization is preferably judicial, but it is not an absolute requirement. If it is not authorized by a judge, then an automatic judicial control is needed over the authorization, and a preferably judicial control mechanism is needed after the application of the measures. This should be the main rule, and there may be some acceptable exceptions. This interpretation is the one that safeguards the privacy rights on a higher level. I would agree with this interpretation, but that judgment can be read differently, and this is how the Hungarian government interprets it during the execution procedure, the judgment. Let's see. Authorization is preferably judicial, but it is not an absolute requirement, and post factum control mechanism, not in the authorization phase, but even after the application, can substitute the judicial authorization as a minimum standard. This interpretation allows the non-independent authorization as a minimum standard. This interpretation allows the non-independent authorization if it is controlled by an independent body after the application. I would like to underline the importance of the independent decision-making in the authorization phase. For me, it is acceptable if the first decision is not made by a judge, but there should be a control mechanism just after this decision that involves the independent judge who can at least order to stop the ongoing activity. Because of secret nature, the individual can challenge the legitimacy of the use of such measures only after it is finished. Therefore, the control mechanism is effective in the individual case only if it is automatic. The decision, if it was made by a non-judicial body, is automatically reviewed by a judge. Taking into consideration the level of intrusion, the post factum review that is made after the surveillance was performed is important but insufficient. Autocratic governments can get the information they want, and they will not take care about what that later it may be judged as illegitimate. Similarly to the restriction of physical freedom, either a judge has to order detention, or automatically or by the individual's initiation, a judge has to review the necessity and the lawfulness of the detention, and this may lead to the disengagement. This mechanism of habeas corpus should be the model of the most intrusive restrictions of privacy. I agree with the court on the importance of the independence of the authorizing and the controlling body. The court prefers the involvement of a judge, but didn't require categorically the involvement of a judge, and this allows the governments to involve less independent bodies, for example, the DPAs, a semi-independent organization. In the Western constitutional states, the bodies with the highest level of independence are the judicial bodies. Their independence is safeguarded by the most effective guarantees. This is why the court prefers the involvement of a judge. But this should be not only a preference, but a requirement. On an abstract level, deprivation of liberty in a concrete case must be made by a judge, or at least there should be a mechanism that brings the case before a judge that can stop the deprivation. This kind of decision requires the highest level of independence. The decision-making body's independence must be safeguarded by the entire set of guarantees that exist in the respective legal system. Other institutions whose independence is safeguarded by only some of the guarantees provide a lower level of protection. Why I think this? One cannot expect a proper balancing of the necessity and the proportionality of such a privacy intrusion from the state organ that is, or at least may be affected by political interests that are not purely legal in nature. On the level of my country, Hungary, the importance of the involvement of a judge is more obvious. During the last 10 years, through a series of constitutional changes, the Hungarian government occupied all constitutional institutions who are not controlling or counterbalancing its use of public power, but act in unity with the government. Their independence became formal, and this is true for the Data Protection Authority as well. Not to mention the current data, when the current data protection authority was set up, it was the same act when the previous data protection authority was dismissed before the end of his term. So the data protection authority was born in an infringement of the independence. But despite the attacks against it, only the judiciary shows the signs of independence and could remain independent from the government. In the Hungarian legal system, no other constitutional institution could resist the attacks made by the government. There are so many kinds of DPAs around Europe and the world. There are DPAs that are similar to the judiciary. In that sense, I would say that they can be the main part of the control mechanism if they are, if their legal status is similar to the judiciary. Now I'm talking about those DPAs that are most closer to the state organs that are belonging to the executive branch. Therefore, I think that any blurred requirement on the involvement of a judge is counterproductive, allows the governments to involve a domesticated institution that we can see in my country. Thank you.
Thank you very much. It was a very critical and very clear opinion about the possible functions of DPAs. Just for clarification, you think that it's not only certain DPAs, for example, the Hungarian DPAs, which are unsuitable, but at the theoretical level, it's not a good solution, that's your opinion, if the supervisory power goes to the DPAs?
It would be difficult to answer this question because it's not about the name and the
yes,
institution in general. I'm talking about DPAs in general are not holding all those guarantees that the judiciary is holding. But there may be in some countries, based on the different constitutional traditions, there may be some countries when the DPAs are more similar to the judiciary than
yes.
the executive branch.
Less and less, I would say. I think we are going to a direction then when DPAs are becoming more authority-like institutions. But we have a DPA on our panel, the Privacy Commissioner of Schleswig-Holstein. I will switch to your slides, but just leave your short CV on the screen, so those of you who don't know Marit could read it. So just a second, and you can start talking, and I will switch to you, or you need your... Oh.
I can start talking, thank you very much. So I'm the DPA here, no, of course the EDPS is there. And we've also many cooperations for the examination which is necessary in this sector. And in Germany, we are doubling the complexity of the European Union with the federal system. So we have a double federal system you see here. We here in Schleswig-Holstein are in the very north, but there are 16 Länder, and every land has own police laws, or not, because they are still reforming them. Then on the federal level, there are several more. And everything has to be, well, in line? No, it's not, because we see that the Länder have different ideas on what to implement, such as is the use of body cams regulated or not, is it permitted or not, and under which conditions, even the terms that are used for that. Interception of communication is now on the wish list. Online investigation, so Trojans being put on your smartphone, something like that. Data retention topics, and even something which is not so much data protection like, but the final shot to save lives, which is now in some Länder also permitted for kids. So if they are very small, but maybe a danger, a risk to threaten other lives, they may be shot. I think this is a case which probably never happens, and therefore even the Green Party does not seem to be so much against it. We'll see whether this will pass in my Schleswig-Holstein police law. But for the other parts, it's really very different per land. And meanwhile, because some have reformed their police law already, there are several appeals before the Constitutional Court, because they don't seem to be in line with our Constitution. And also there's something like the fuzzy term Gefährder, that means somebody who threatens. And what is allowed to do with a Gefährder? If I say he's a Gefährder, then there may be different things I can do to monitor him, or well, there are some. I think it's not the worst world right now, because you won't be put in prison yet. But on the other hand, it's something where it's so difficult for everybody, for the person himself, but also for the others to check what are the criteria, and is it some opinion or a fact? So this is really something where I think there has to be a line which has to be discussed. And now I present you a kind of a wish list from 2019. Which I'm really very anxious about, from the Ministers of the Interior and also the Ministers of Justice, so where I don't think that, I didn't expect that. And this is about access to encrypted communication in messengers, which probably means some kind of backdoors. It's about access to smart home data. Okay, if you go there and you always can get to the data stored with child's rooms if you have the right to be there. But not only the rooms, but also the data as such. But then the federal minister also said he wants to get access to the processing. So like remote checking what is happening in the smart home. The other ministers did not say that. Weakening security of 5G. 5G is now an opportunity for better built-in security, and now the ministers of justice say, well, but then the IMSI catcher won't work anymore. What about the interception possibilities? So the standard security has to be weakened before we roll it out. Now the last thing was the demanding of the passwords from providers. And they said, yes, we have encrypted passwords, but what do you want to do with them? No, we want clear text passwords. Well, the Minister of Justice didn't even think that there would be a shitstorm which happened. And something where it's about, again, fuzzy terminology. What about the provision of services that enable criminal offenses? This is something where people who provide a Tor node or offer some encryption services may enable criminal offenses. If I sell goods, I may enable criminal offense. So people may be criminalized, and I don't think this is a good sign for a state. The lack of transparency for data subjects. This is something which is really very typical for law enforcement. Very late people get to know if there is something happening, or sometimes they are not informed at all afterwards. And therefore, in 2013, the Federal Constitutional Court in Germany had a ruling that the DPA audits are mandatory at least every 2 years. And now we see, it may even happen that we wake up and there has been passed a new law, that this instrument is being put in so many laws. In the Schengen Information System Regulation, the Visa Information System, the Eurodac, the Entry-Exit System, ETIAS, every law, meanwhile, contains something like that. There has to be a check, which is good, I think. But then this is the problem Fanny was also mentioning. The supervisory authorities get now new tasks. By the way, they didn't know beforehand. They didn't plan in their budget. They didn't have people for that. So they have to beg afterwards, saying, please, people from Schleswig-Holstein, we need more people to do the checking, because we have to meet now I think, twice a year, and then write reports for our checking every second year. And this has to be in a harmonious way, which is also very difficult how to do that it's a meaningful check and not something where people ask, is everything all right? And then, yes, nodding, fine. No, we really have to do a good kind of checking. I think it's a good instrument, first of all, although it's very difficult if we only find something where the checking is not really possible. And then we read again the court ruling from the Federal Constitutional Court. And there it's clear that it has to be evaluated in a practical manner, which means the system design has to enable the checking. And this I haven't found in the laws. So there's nothing like you have to construct your law in a way that DPAs or others can do the checking in a meaningful way. What is being logged? Okay, there's something more now in the directive, and I personally think it's very good to distinguish whether I'm a victim or a convict, okay? But that because there are different rights and different deletion times. But the practical manner, I think that we are lacking that very much. And with new technologies, you have seen the wish list, artificial intelligence, it will become even more difficult. So this part of the ruling, I think, has not been picked up well. And now something very practical. We're not so much right now in artificial intelligence checking. Sometimes we ask for some algorithms and the answers are not very sufficient, but usually it's not in a phase, at least in my land, where there has happened already something which was unlawful. But here we have two things which were very noteworthy in Germany in the last time. With Hessia, the police people wanted to know about a person, Helene Fischer, from a concert. They checked her up, only to see what is about her in the database, because they probably like her. Only to see 83 people wanted to have a look up in the database, but they couldn't argue, and this was found later on. Or a thing in Mecklenburg for Pomerania, in 3 cases, really old school methods. There were girls, not even at legal age, a 15-year-old accompanying a victim of some criminal activity, and another a person, a youth, being photographed, and her photos were online, and she complained, and kind of mobbing activity. And the young policemen, they checked up their phone numbers and wanted to get in contact, because let's meet afterwards. And I'd like to take the photo, and they did some photography session with the photography victim to put it online. So I really don't understand that, probably because they liked the girls. But this means we have very old school misuse here. What about the wish list now? We cannot even control beforehand what is happening here. And if we have the online investigation and a nice person I want to meet later on, or a not so nice person I want to harm, then I really get into some troubles, and only ex-post checking, I think, is not sufficient. Another question for the audience. Data breach notification, Article 30 in the Directive 33 GDPR. How many did we receive in Schleswig-Holstein? Your estimation. 6,500 employees, police officers, 6,500. And now, do you think more than 100 data breaches notified last year? More than some people. More than 50. You have to more than 10 notified. More than 1. Okay, 0. Everything is so fine with the police. Nothing has happened. No, they haven't established any kind of. You have to do the notification. You have to check whether there's a data breach. And something like, we are the good ones. We are the ones who have to enforce the law. So we cannot be on the bad side. And this is really a problem. There's perhaps a little bit of hope that people from the police officers are also becoming data protection officers and are being trained with us. And afterwards they claim they have been brainwashed, but that means they can see both perspectives. And usually it's a very good thing afterwards also that they can be honest with us and tell us some things. But this is nothing as like the control we were here demanding. So thank you very much.
Thank you, Marit. You prove that there are ways and means to use your supervisory power in a sensible way, so to say. So this is a good sign. Okay.
I did one more. Sorry. Here.
Okay, but I should go back to the original slideshow, and after the last, that's you, and after the last, and then please.
I may. No.
No?
So
the other one back?
I pass on the responsibility.
Okay. No, we can't use it. Just a second. Can I have the controller? Thank you. And the last voting. So the voting question is the algorithmic policing, in your opinion, is great. It's a tricky question. It oversimplifies like all the others. But please try to vote correctly according to your opinion. Is the interest in algorithmic policing is creating new privacy and data protection issues for DPAs? That's the first option. Second option, it is creating new privacy, data protection, and human rights issues. And option 3, it is not creating new issues at all for DPAs because all such problems can be solved within the existing legal framework. So who would vote for option 1, that's creating privacy and data protection issues only? 2, okay. Who thinks that option 2 is the right answer, including human rights issues? Yes, the great majority. And who is at the opinion that it's not creating new issues because everything can be solved within the existing legal framework? Maybe 2.5. Yes, thank you. Now is the turn for internal discussion before I open the floor for questions and comments from the audience. I saw that all of you made notes while the others were speaking, so it's the time to react on the previous speakers on the panel, including Charles, of course, if he also made notes. I saw. So who would like to react on each other's statements or presentations?
I'd just like to ask either of the any of the panelists the following question. If the directive requires an obligation to take note and categorize a fact and opinion, in the light of algorithmic policing, where do we put inferences? Why is that not a legal obligation, and why do we not have a place for that to be written down and categorized? And should that be a rapid amendment to the legal framework?
Is it a question to Marit or
to anybody on the panel?
To the panel.
Okay, if it's in inference, I think is not a fact yet. There may be something which then becomes a fact, but then you have to prove it in a kind of way which can also be afterwards checked by a judge, for example. So right now, if it is only, opinion would also be a little bit difficult because whose opinion is it? It's more an inference.
Yeah.
Fanny, you emphasized the difficulties in supervising such a complex system, and the data flows between the systems are greater and greater. In your personal opinion, from the data protection point of view, is it better to share as many personal data within the agencies as possible, or to collect data, more data, within the national legislation, within the national borders? It's a theoretical question because the situation is there, but in your opinion, which one would you prefer?
So what do you mean, that data would stay at national level? And
that the police and the law enforcement agencies collect a lot of data in-house, within the national territories, or they use the already shared data of shared databases. From the data protection point of view, which is a better solution?
That's a difficult question.
Yes, it is. We don't know the right answer.
It depends. I think the reality that we are more going towards a more data exchange. But I think we will be faced with two realities, not mutually excluding. It's not like we go for option 1 or option 2. I think the two things are happening at the same time. National authorities are collecting more data because more data are available to them. They are getting the tools also to process that, and they need to they are fostering also the collaboration elements. So I think each of these two questions raise difficult data protection question, in my opinion, and I wouldn't be able to make a choice, actually.
Yes.
Can I add something for this?
Yes, Maté?
It would be important, because I think data sharing is not a bad thing per se, if there are control mechanisms, and I think it would be important not only let those states that are where the police and law enforcement agencies are working, let them to control their use of data, and not only those countries should control where the data are originally collected, but those countries should be let control these data flows where the individuals are originated. And this is what an earlier panel yesterday was talking about, a new directive on data sharing and an amendment to this from the European Parliament, that these three involved countries should be somehow involved in not only in the data flows but in the control mechanisms as well. And if there are strong control mechanisms, then it is not a...
Yes, Marit?
Yeah, so I think for our police data, there's this huge chunk which should not be shared because it's something very domestic and only in a very small area. It's nothing which should be linked. Because if I hit my neighbor because he provoked me, then probably not Europe should be able to do that. If I travel around and hit everybody, perhaps this is a different story. But we see a big part which does not has to leave the boundaries. But we had another thing, a warning against a translator for judges, for courts. And there was said she had a relationship with somebody in prison. And this was a warning issued to all our Länder and on the federal level, and nobody informed her. And then everything cleared up, but not the clearance was not passed at the control thing. And now she cannot work in most of the Länder because there's still something where they don't know whether there has happened something or not. It's so difficult if the sharing is happening in a non-controlled way.
Okay, now I open the floor for questions and comments from the audience, and we have only one mic, so I will borrow your mic. Yes, could you? Yes, and I will choose this one.
Yeah, hello, I'm Hartmut Aden from Berlin School of Economics and Law. Thank you very much for organizing this very important panel. I think when we look at the policing or law enforcement directive, I think today we only talked about the first stage, what is transposition into domestic law, what is still with many deficits. But then the second step will be application, and I think your example is already quite evident that there will be many issues if they do not use in practice, for example, data breach notification, but this is probably even more important, for example, for data quality management or also for the tracking of the transfer of data. So I think this is really a huge field where probably indeed DPAs will need much more staff in the future. And this is, of course, also the case for the interoperability things. I think it is good that we have these clauses in the new regulations that the DPAs have to cooperate, but of course they have also to be enabled to do so. Thank you.
Okay, would you like to respond to this, or let's collect some more comments and questions? Alexander, please.
I think. Hello, my name is Julia Balasch from the Danish National Police. So, as you can guess, we have a lot of comments, and I think, especially with regards to Mr. Leiser and his remarks about the difficulties there are with categorization of data subjects and information. I think it is really important to remember that that data protection cannot be seen as a singular issue, and that the police is one of the most regulated public authorities there are. So we actually operate in a legal sphere that is regulated also by by criminal process laws, etc. So we have actually a lot of experience with classifying data subjects, so the people that we deal with, because that's part of criminal procedure, because you need to know who is your victim, who is the suspect, and who is someone that was of interest and is no longer of interest. So that is something that I don't see as an issue at all, because we've always been dealing with that. And the same with also classification of information. Of course, there are established procedures for when information can count as evidence and when information cannot count as evidence. So I think we need to remember that law enforcement also acts in a different sphere, and I fear sometimes that we forget that that there are these other issues and not data protection only. So I was also very grateful for the comments with regards to whether DPAs are actually equipped to deal with all the issues that data processing in law enforcement poses. I think there are certain issues, and I agree with Marit with regards to data sharing, data quality issues. There needs to be, of course, a lot of a better equipment of DPAs to control these information flows that go within Europe, because there we also see problems. And I think we should not put this up as a dichotomy where police is opposed to data protection authorities, because we, of course, have an interest as well in correct and accurate information, because otherwise we cannot do our work. So we would actually be looking forward to data protection authorities helping us transpose the directive in a meaningful way and help us to interpret these rules, which can sometimes be quite unclear and a little bit flurry. So that's just a comment.
Okay, thank you very much.
To show the other side.
Could you please bring the mic here to Alexander? And as you see, we have 5 minutes left. You can see my stopwatch. So we collect all the comments and questions, and then a last round of the panel.
Thank you. Alexander Dix from the European Academy for Freedom of Information and Data Protection. With regard to Maté Szabó's input, I have a question to you. I very well understand your position from the very Hungarian background you were referring to. However, from a more general point of view, don't you think that it is essential to have an independent auditing mechanism in the police area and actually everywhere else? Because courts only get active once there is an actor. Someone brings an action. Without an action, no court will ever get active. So I think it's crucial that police and any other controller is being monitored continuously, ideally, continuously 24/7 is not possible, but there needs to be a monitoring mechanism, and I'm somewhat critical, even coming from Germany, as to your trust to judicial institutions as such, because judges tend sometimes to automatically authorize surveillance measures or maybe even detention from a practical point of view. I don't say each judge does that every day, but judges get forms in front of them put by the police and they put a stamp on it. So there is a need for an additional monitoring mechanism. What happens afterwards? What happens to the collected data? And therefore I think it's crucial to have some kind of independent mechanism. I personally believe the DPAs, if they are equipped well, which they are not at the moment, are the right institution to do that.
Could you please give back the mic to me? That's not very polite, but we have only one mic, and I must turn back to the panel. Could you, Maté, briefly respond to this? And then we have a last round of
I would like
notes.
to make clear that my comment was related not to the post factum monitoring control mechanism, which is a general one, but I was talking about the individual decision making on the question if use of a secret surveillance measure is allowed or not allowed in a concrete case. So what brings the case before the court is the request for a warrant normally. So it is okay. But the main argument why I say this is that the court should do this because it is the only state organ that is able to balance, to properly balance the necessity and the proportionality, can balance the interest for and against using these instruments.
Thank you. So, Mark, would you make your last comments in this panel?
Yeah, thank you very much. I just wanted to address a couple of the comment that was made earlier and then a comment made by the Danish police. I'm well aware, in fact, I'm very critical of the fact that sometimes we look at data protection without looking at the bigger picture. I don't know that it is necessarily right or appropriate to tie categorization to automatic deletion, which is my primary concern, and also to enforce data subject rights or to allow data subjects to enforce their rights based upon a category of data. The second point I would like to make is that I go back to this idea of facts and opinions. An inference doesn't always become a fact. I think that's a misstatement. And I think that one of the things that we have to do, if we are going to argue that the data protection regime is to give data subjects stronger rights is that inferences, especially in the age of algorithmic and predictive policing, would be and should be an appropriate category to mark data against. I don't think it's a stretch of the imagination to give people that a little bit of additional information relative to the information that's sitting against their name.
Thank you. Fanny, would you like to make a last word, last comment? Very brief, please.
I would like to second what Marit said about importance of system design to enable the checking and supervisory authority, because we can see that sometimes the way how the system has been designed actually prevents us to get some information we would need to do the supervision. And this is very important to thinking from the beginning. I would like to react also to the fact that DPAs are semi-independent authorities. I hope they're not, because this is a constitutional requirement in the EU Charter. So then there is a real need to work on this, because this is enshrined in the EU Charter.
Marit, your brief response to this?
Okay, so only looking into the law again, so in the regulation, the powers say at the last thing that the supervisory authority should also have a corrective power such to impose temporary or limitation, including a ban on processing. This is not happening. So in very, very few reform laws, we see that this is a power that the supervisory authorities get. And in Germany, there's one land, I think, where it's possible. And only to say, if we are the independent ones and have to stop perhaps during a process, not ex post, because otherwise the laws, the judges would be later, then this is a stop here right now. We don't have that power, and probably this is against the European law.
Unfortunately, we are running out of time. There are a lot of questions and comments still can be made during the coffee break, but I would like to ask Charles to give...
Thank you very much. I have two comments to make. One is by way of analogies. I've been thinking that what we've been hearing is there's a kind of blurred boundary between what we regard as law enforcement and that whole system and what we regard as not necessarily law enforcement but other areas of civilian life. In the UK, we have the police have what are called the Peelian principles, established by Sir Robert Peel in 1829 when he established the Metropolitan Police. And one of those, which is drilled into the heads of all police people in the UK, is that the police are the people and the people are the police. That is to say, it's not a militarized force, a separate cadre of people, but rather integrated with society, and they depend upon each other. And therefore, there's this kind of, the analogy is that there's a sort of flow. There's not a rigid boundary between what we regard as one domain and what we regard as a civilian domain. And I think that's a nice analogy to what we've heard today. The second thing is that I carry a knife. And Marit mentioned, what about people who supply equipment which could be used for criminal purposes? Well, this is a triple-use piece of technology which I carry because I do a lot of drawing, and this I use to sharpen my wooden pencil. It also has a bottle opener, which I rarely use because I don't. It doesn't have a corkscrew, unfortunately, which I would use more frequently. But in any case, and this is probably a CPDP first, somebody waving a lethal weapon, because I can do a great deal of damage with this. I might not be able to kill you, but I can do things with it. Now, therefore, does my carrying of the knife or the design of the knife, because knife crime is a big deal, and therefore there may be regulations about what kind of knives you can design, does that fall into an area where law enforcement and the law enforcement domain might be operating? So these are just analogies, but you saw it first here in CPDP.
Thank you very much. Thank you for the panel. Thank you for your participation, active participation, and let's continue talking during the coffee break. So, goodbye.